Hey guys, it's Kathy. Happy, what is today? Sunday or Monday, depending on where you are. Actually, I think it's still early enough in the morning that it might still be Sunday in New Zealand and Australia, right? Actually, if you guys come on, let me know. If not, happy Monday. I got, I don't know before I thought it was a full moon. The full moon is tomorrow. Now I understand. Now I get it. Nobody wants a lawyer today. Nobody wants their lawyers. So the prisons got bloated today. They got bloated today by people making bad decisions. And then I also have a custody case. That's sort of this guy's in a tough spot, but there's really only one clear choice. But let's start off. Okay, at the first part of this first one, we have a hot mic issue, and then we go into the pro se guy. So here we go.
Um, Let me just converse with Carolina real quick.
All right.
On Espanol, Alsami, we do have the defendant present, but we're waiting on, I believe, the state's witness who speaks Haitian Creole, but might be able to understand a little Spanish. Am I?
So the defendant speaks Spanish and the witness speaks Creole.
But may understand Spanish, Oscar? Okay.
All of that is correct, Judge.
If we have competing interpreters, there's no way we could do it remote. We're not supposed to be doing remote NCOs anyway. I'm not sure why this is set. So we'll try, I guess, if everyone shows.
Judge,
Uh,
this was set before we had filed the NCO. It was originally set as a bond motion.
oh, okay.
He's
All
now
right.
bonded
Okay.
out. If we can't do it, it looks like our witness just appeared. If we can unmute her, we can see if she would feel comfortable moving forward in Spanish, or we would just ask to reset this as soon as the court can in person.
All right.
Let's
What I'll do. Yes,
go ahead.
Jess. Okay. What I'll do, Oscar, you're bilingual, yes?
Yes, Judge.
I know we're on the record, recording and live, but we're not going to call the case yet. Informally, I will let you address her to see if she can do this in Spanish.
Okay. Señora Frederick, ¿me puede escuchar?
Sí,
Ahorita tenemos un intérprete para el español, pero en creol todavía no. ¿Está bien haciendo la audiencia en español o prefiere esperar otro día por un intérprete de creol?
ah, voy a traer una persona para explicar el español.
¿Es suficiente?
Counsel, was she responding in Spanish?
Yes, she was, Judge, and I think she's willing to try it in Spanish.
Okay. Is this to just kind of let's call the case then, Jess, and talk a little. Well, I don't want to talk yet. No, hang on. I want to be off record on it, even though we're recording. Is she good? You anticipate she's going to request the NCO be lifted?
Yes.
Are there any children?
Yes.
All right. State, is that kind of what you're anticipating as well?
Yes, Your Honor, we were anticipating. I tried to talk to her yesterday, but our interpreter mentioned that her Spanish wasn't that great. So I'm not sure what to expect just yet.
All right. Turning back to Miss Jessica, our court staff. Jess, do we have a Haitian Creole interpreter on the way?
I am not sure. I requested it at 4:16 p.m. and Carolina told me that she doesn't see that one was ordered for this morning. So I did my
Okay.
best. Okay.
Thank you. Oscar, do you want to try all Spanish today or set it in person this upcoming week?
I mean, I'll keep my questions short, Judge. I would like to try it today.
All right. State versus Alsimi, 49D342403 F60076661. Madam Interpreter, state your name.
Lena Salter.
You swear will affirm under penalties for perjury. Your interpretation today will be from English to Spanish and Spanish to English, fully, fairly, accurately, and truthfully, the best of your ability.
Yes, I do.
All right. Please, Oscar, what's your witness's name again?
Her name is Charlene Frederick.
Madam Interpreter, please confirm Charlene Fredericks on the call.
La señora Charlene Frederick está aquí en la llamada. Señora Frederick?
Sí.
Yes.
Ms. Frederick, we will try this in Spanish. If at any time you don't understand what's going on, just tell the interpreter.
Señora Frederick, vamos a intentar hacer esto en español. Si en algún momento no entiende, por favor, me lo dice.
Yeah, talking to some Mexican chick.
Wow. All right. Please make sure you're muted. And if I find out who is saying anything racial, I will hold you in contempt remotely and issue a warrant for your arrest. Please make sure you're muted. That was offensive. Thank you. All right, Jess, I might have you look into who said that if you can figure it out. We'll
It's
deal with
probably
it.
one on our list this morning.
I'm sure. Okay.
So, okay. So they didn't say in court what happened to him, but it was clear who said it once the docket went forward. So he probably got held in contempt of court. Because what an idiot. All right.
We can do State versus Teresa Simmons.
Yes.
49D 34 2210 CM 028909 49D 34 2212 F6 034496. Both are violations, counsel.
Judge, I advised Ms. Simmons that it wasn't likely that the warrants would be recalled unless she surrenders herself to the court. So I don't really know what to do here, Judge.
All right, so failure to appear warrants were issued February the 8th. And you represent her?
We're appointed on the violations, yes.
Okay. Well, I'm your neutral and detached magistrate here, ready to listen to whatever you want to put before the court.
Judge, I'd be asking that she be ordered to come to one of our probation days and see if we can get this resolved, have the warrants
Okay.
recalled until then.
All right, Ms. Simmons is going to give you an order to appear in court at the Community Justice Campus, Court 34.
I had explained
Jess-
to them, I no longer stay in Indiana. I was in
That's
the process.
Ms. Simmons, just a moment. Now, counsel, your client wants to start obviously putting things before the court.
Yes, Judge. She made me aware of that, but again, my advice was she was going to have to surrender herself because I don't believe she was given permission to leave the state.
Okay, that is an issue, and she probably then needs to watch herself when she addresses the court. The minute she says, "I don't live in state," if she left without permission, that's a new violation.
I understand, Judge.
Yeah. Okay. She has
the
your
nature of
contact,
my case that I took a plea.
ma'am. That'll be
something
quite
that-
enough. Thank you, ma'am. She
I
has
say you're
your
not even letting
info.
me speak.
She does, Judge. Based off the email I received yesterday, I'm not sure she wants my representation any further. So that could also be another issue, but I'm still on the case until,
Are you telling me you have reasons for me to do a hearing to see if she wants to waive her right to counsel?
Based off of the emails I received yesterday, it does seem she does not want my assistance.
Ms. Simmons, do you want the public defender's office to represent you in these probation violations?
Yes, I would like to be assigned someone else.
Okay, I don't have anything to do with that. I just assign the agency and then they assign the lawyer. So I have nothing to do with who actually represents you. But she did answer in the affirmative that she still wants the public defender. What I'm going to do is, so far, what I've heard is it sounds like she may in fact be out of state. The warrants will remain active. I'll set a date out in a few weeks for the lawyers and Ms. Simmons to figure out if they need to continue those dates, if they want to put more things before the court. But I'm going to go ahead and conclude the remote portion of this litigation and order the defendant to appear on a Thursday. Otherwise, the warrants will just remain active. And then at that hearing, she can obviously address the court. Jess, a Thursday in due course, please.
Let's do April 18th at 8:30 in person.
All right, defendant's ordered to appear then for a hearing. Call your lawyer with questions about your situation or anything you want to put before the court. The warrants remain active pending that hearing. And I'm going to conclude this remote hearing. Thank you.
Thanks, Judge.
Next case.
Yeah, let me unmute someone.
Yeah, that was real smart. I don't know what the email said, but she clearly ticked that letter off. It sort of reminded me. I don't know if you guys remember. I had a stream with Underwood. Is it Rhonda? Rhonda Underwood, where he wanted her off his case so bad, and they had a breakout session, and she came back and she was furious, furious, and he said that he wanted a new lawyer. Blah blah blah. Well, then like a month or two later, he picked up a new charge and she was the public defender on for that day for initial hearing, and he went off. He's like, I don't want her helping me. She says, I'm all you have for today. I am on today. That doesn't mean I'm going to be appointed to you. But that's what that reminded me of. Okay, we're gonna get it. We're just gonna keep this whole thought process going.
Good morning, sir. Can you please state your name?
Robert Brown. How are you?
Doing well, sir. All right, so we're here for an initial hearing in cause 54 DO2 2301 CM 133. First, Mr. Brown, can I get a good mailing address for you?
7933.
What was the first part of State Road 234?
234.
What is a good phone number for you? Do you have an email address you use?
I don't, sir.
All right. So the state has filed a petition to revoke or modify probation. They allege that on May 15th of last year, you were placed on formal probation for 180 days in this cause for the offense of criminal mischief, a class B misdemeanor. And October 16th, an agreed violation was filed extending that probation for 270 more days. Among the terms and conditions of that probation, you violated the following conditions. Term 2, you're to report to and cooperate with your probation officer as directed. On August 29th, October 10th, December 20th of last year, January 18th, February 5th, and March 4th of this year, you failed to report for scheduled appointments. You're to provide your address and telephone number to probation at all times and in advance of changing your residence. On or around July 21st of last year, you failed to provide a change of address to probation, which was discovered during an address verification check conducted on July 21st, 2023. Term 4, you're to maintain employment, notify probation prior to any change in employment. If not employed, you'll actually seek employment. As of March 7th, you'd failed to obtain employment. Term 7, you're not to consume or possess any controlled substance or synthetic drug except as prescribed for you by a physician. You're to submit to an alcohol and drug test even when ordered by probation, community corrections, or law enforcement officers. By signing this order, you waive any objection to the admissibility of those results. On May 30th of last year, you admitted to ingesting spice. On August 4th, January 29th, and January 31st of this year, you provided urine drug screen returned positive results for marijuana. On August 31st, you admitted to ingesting methamphetamine. On August 27th of last year. On September 15th, you admitted to ingesting marijuana within the last 14 days. On October 4th of last year, you admitted to ingesting marijuana or THC within the last 7 days. On January 29th of this year, you admitted to ingesting methamphetamine. On February 21st and 26th, you failed to provide urine drug screens as directed. On February 27th, you provided urine drug screen that returned positive for marijuana. Affirmative sworn under penalty of perjury by Gabriel Kirk, probation officer. If the court were to find you in violation, the court could either place you back on probation on your original or modified terms, or could revoke all or part of your suspended sentence. Do you understand the allegations against you and possible penalties?
I do, sir.
All right, you have certain constitutional rights. You have the right to a trial to the court. You have the right to be presumed not in violation unless and until the state proves a violation by a preponderance of the evidence, or more likely than not. You have the right to confront and cross-examine any witnesses against you. You have the right to have witnesses come into court and testify on your behalf. You have the right against self-incrimination as it relates to any allegations of a new offense, and you have the right to appeal any finding of violation. Do you understand you have all those rights?
Yeah.
You also have the right to be represented by an attorney. And if you cannot afford one, the court can consider appointing one for you. Do you plan on hiring an attorney? Do you want me to consider appointing one for you?
I I don't know.
Okay, so I mean, your options today would be go forward on your own without counsel, or I can consider appointing an attorney for you.
Can we continue today?
What do you mean?
Like, to get this over with?
So you're saying, well, first we got to address the issue of counsel. Do you want to have an attorney?
No.
You want to go forward on your own without an attorney?
Yes.
You understand you'd be held to the same standard as an attorney and understanding any rules of evidence or any trial procedures?
Yes.
Okay, so you have three options. You can either admit the allegations, deny the allegations, or remain silent as to the allegations.
I admit.
Okay.
I did the best that I could, and I had problems. Just to make it short and sweet, I did go to multiple rehabs, graduated. I learned a lot.
Well, hold on, sir. We can get to the how and why here in a second.
Okay, I'm sorry.
So I'm gonna have you raise your right hand.
Sir.
Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Please state your name.
Robert Brown.
Mr. Brown, you've been advised of all of your rights and what could happen in this case, correct?
I have, yes, sir.
And is it your intent to go forward without counsel and admit to these allegations?
Yes, sir.
Were you on probation in this cause for a period of 180 days, and that last October that was extended for another 9 months?
Yeah.
And we're on those dates, August 29th, October 10th, December 20th of last year, January 18th, February 5th, March 4th of this year. Did you fail to report for scheduled probation appointments?
I called him. There was some things going on. I didn't have proper transportation. I had everything set.
Well,
I was doing. Things mess up, you know.
So
I
to establish
did
the
call
factual
him.
basis, you
Right.
called him. Did you fail to report to probation?
In person, yes.
Okay, and were you ordered to provide your address and telephone number to probation at all times?
Yes, but there was
And on July 21st of last year, did you fail to provide a change of address to probation?
No.
Okay, well,
Yeah. Yeah, you're probably right. And
you did fail to report that change of address?
Yeah, yeah.
Was another term that you to maintain employment, notify probation prior to any change? And as of March 7th, had you failed to obtain employment? You have to answer out loud, sir.
Yes, sir.
Okay. And term 7 is you're not to consume or possess any controlled substance or synthetic drug except as prescribed for you by a physician. Was that a term of your probation?
Yes, sir.
And on May 30th, of last year, did you admit to ingesting spice?
Yes, sir.
On August 4th, January 29th, August 4th of last year and January 29th and 31st of this year, did you provide a drug screen that returned positive for marijuana?
Yes, sir.
On August 31st, did you admit to ingesting methamphetamine on August 27th of last year?
Yes, sir.
On September 15th, did you admit to ingesting marijuana?
Yes, sir.
On October 4th, did you admit to ingesting marijuana within the last 7 days?
Yes, Your Honor.
On January 29th, did you admit to ingesting methamphetamine?
Yes, Your Honor.
On February 21st and 26th, did you fail to provide urine drug screens as directed?
Yes, sir.
On February 27th, did you provide urine drug screen that returned positive for marijuana or THC?
Yes, sir.
Any questions on the fact state?
Briefly, Your Honor. And Mr. Brown, did you ever make full restitution as ordered as part of your probation?
No, sir.
Thank you, Mr. Brown.
Thank you.
Is the state at all prepared to go forward on disposition today?
Your Honor, the state does not have a recommendation from the probation officer.
So, Mr. Brown, what I'm going to do, I'm going to set out disposition. I'm not going to set it out too far so we can get a recommendation from probation. And
Can I ask a question?
yes, sir.
Can I get an OR until court?
So where I'm gonna keep the bond set in the amount of $1,000.
I don't have any cash and then and no property, no nothing. And
Okay,
there's a reason why I'm asking.
I understand that. So I'm gonna keep the bond set today. However, I am gonna set this for disposition.
I just want to go home. So bad.
We'll do that next Monday at 11.
Okay. Is that like this coming Monday?
Yes, Monday, March 25th at 11 a.m. We just need time for the state to be able to get a recommendation from probation, see what their position is on this violation. So we'll enter that you've admitted to the violation. We'll set this for disposition next Monday at 11 a.m.
Okay.
Okay, that's all for today, sir.
Thank you.
Yep.
I think in his head he was going to have an opportunity to just explain it all away. And that judge wouldn't let him explain anything, just the facts. Did you do this? Yes. Okay. I don't care why. I don't care. I don't care. Maybe if he had a lawyer, but no, he said no. But you know what, guys? There's more. We're going to keep this whole train rolling.
At 11 a.m., Your Honor. Thank you.
Sorry, I didn't realize there was a pause.
Thanks. Good morning, sir. Can you please state your name?
Austin Bouquet.
Mr. Bouquet, this is cause 54D02 2201 F6122. First, can I get a good mailing address for you?
I mean, I don't have a mailing address. I'm kind of trying to figure my stuff out now by doing all this.
Okay. And do you have a phone number?
No, that's what I'm saying. So either way, it's gonna be this. Either way, it just happened 2 days earlier.
All right.
I don't have anything to give you.
Any email address?
I give you the email address. Yeah, I got that.
What's that? Austin Bouquet. .com?
Yes, sir. Sorry.
Okay. Just couldn't remember if it was a .net or .com. All right. So the state has filed a petition to revoke or modify probation. Let's see, where it's alleged you were put on probation on this cause on March 21st of 2022 for a period of 545 days.
How long is that? 3 or 5 years? I forget. Sorry, sir.
So it's 545 days, which is a year and a half. And that entire sentence was suspended. Term 2 was you're to report and cooperate with probation as directed. It's alleged that you've not reported as instructed. You were sentenced on March 21st. Were instructed to report to probation. You were released from Montgomery County Jail on April 3rd of 2022. Was instructed to report to Montgomery County Probation within 3 days, and you did not report as instructed. Affirmed and sworn by Mark Bickle, probation officer. So if the court were to find you in violation, the court could either place you back on probation on your original or modified terms, or could revoke all or part of your suspended sentence. You
I'm
understand?
cool. Yeah, I'm cool with it all being revoked during my time here. I just don't want to sit for 5 straight years.
All right, so do you understand the allegations against you, the possible penalties?
Yeah, I'm cool doing my time here though.
Well, so you've got certain constitutional rights. You got the right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proved your guilt beyond a reasonable doubt, or not beyond a reasonable doubt, beyond preponderance of the evidence, or more likely than not. You have the right to confront and cross-examine any witnesses against you. You have the right to have witnesses come into court, testify on your behalf. You have the right against self-incrimination as it relates to any allegations of a new offense. And you have the right to appeal any finding of violation. You understand you have those rights?
Yes, sir.
You also have the right to be represented by an attorney. If you cannot afford one, the court can consider appointing one for you. Do you plan on hiring an attorney?
No, I mean, I'm guilty.
You want me to consider appointing an attorney for you?
No, I mean, what, they can't help me. I mean, I already signed the
They can
plea.
advise you of your rights, how to present a case to the court, follow any rules of trial procedure. Do you have any interest in having an attorney help you through this process?
No, I already signed the plea. I'm guilty. It's all good.
Okay, so that was on the underlying criminal case. This issue is whether or not there's a violation of probation. If there was, what
No, there is a
sentence could
violation
be.
of probation. I left by probation, never showed up. It's all good.
Okay, so you've got three options today. Option one is, well, three possible answers. You can either admit the allegations, deny the allegations, or remain silent on the allegations.
I'm gonna admit the allegations. I want this over with.
Okay, please raise your right hand. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
I confirm. I swear it's nothing but the truth.
You put your hand down. Please state your name.
Austin Bouquet.
And Mr. Bouquet, were you placed on probation in this cause back on March 21st of 2022 for 545 days?
Yes, sir.
And was one of those terms you to report to and cooperate with your probation officer as directed?
Yes, sir.
And did you ever check in with probation?
Never once seen him.
State any questions off that?
No, Your Honor, thank you.
All right, so the court is going to find Mr. Bouquet in violation of the terms and conditions of his probation that he failed to report to probation as directed. State prepared to go forward on disposition today?
Yes, Your Honor.
All right, Mr. Bouquet, is there anything you want me to know before I decide what happens on this case?
No, I don't think it's too long. It's all good. It's all good. Sorry, sir.
Say any evidence?
No evidence, Your Honor, just argument.
What's the state's position?
Your Honor, the state would respectfully request that Mr. Bouquet's sentence be revoked in full. The state will note for the court that Mr. Bouquet was on probation when he was originally sentenced in this felony cause, and there was another pending misdemeanor cause. Both of those causes were closed out. Mr. Bouquet was given another opportunity at probation. By his own admission, just didn't appear, was wanted on warrant for approximately 9 months prior to being attached on that, making no contact with probation. So at this time, the state does not believe that Mr. Bouquet is an appropriate candidate for probation.
All right, I agree with that, and based on your comments today, Mr. Bouquet, I think you agree with that too. So I'm going to revoke the entirety of that suspended sentence. It's going to be 545 days to the Department of Corrections. And once you're done with that, you will be done with this case, and I think have no other pending causes here in Montgomery County.
So once after all that, I'm out. Good, free go. That's what I wanted.
So it's 545 days, subject to Class 8 credit times was actually 272 and a half actual, and you're going to get credit from the time this warrant was served, which was March 19th.
All right. So
Okay.
do I gotta go come back to court after this? I'm sorry, I'm being odd.
Nope. No, you're done, sir.
Sure. Thank
That's
you.
it. Yep. Good luck, sir.
Yep, those are both Zoom. Indiana prisons got fuller today because of these people. No, I don't need an attorney. They could have put them back on probation. They could have said, Judge, listen. He didn't understand. He lost his phone. His dog had cancer. He had to take care of his 4 kids. But he doesn't have a job. But he starts tomorrow, and he volunteers at the food bank, and his great aunt's sister's brother's niece really needs him because she had a bone spur, their surgery. His lawyer could have said all of that to the judge, and the judge would have said, yeah, that checks out. Probation. We'll put you back on probation. Instead, they said, no, I don't want an attorney to say all those things. I'm just guilty, so just give me the maximum. Just don't let me off easy. Are you sure it's not 5 years? Just give me 5 years. Now we go to a custody case. Well, it's not a custody case. It is a custody case, but it's not a custody case. It's a DV case, and there's a child involved, so custody comes into play. But this is not the custody hearing. This is just the domestic violence hearing. And the guy is in a rough spot. I understand. I just do understand, and I bet a whole bunch of people here understand too. They need help. they need help raising the kid, but the partner's not the best person, but they don't have anybody else. All right, so we're gonna listen to it. Here we go.
And we're coming back to Miss Pinson. Is that right?
Yes.
Did I say that right?
And there was an additional issue beyond the fact that I think the alleged victim's online or was online. We got to keep the peace, and Miss Pinson just wanted to make sure she didn't need to sign anything, or what she was given was good to go, right? Okay. But then we also heard that the AV was online.
Okay, so I'm coming back to my notes for Miss Pinson. This is 24 CR 1032. Lauren Pinson is present in the courtroom. I need to find the case on my virtual docket. And do we have the named victim in this case present today?
Yes.
Sir, what is your name for the record?
Joshua.
Can you please state your full name?
Sorry, Joshua Terrell Womack Jordan.
Thank you. And what would you like to address today, sir?
Well, first, so what? I missed the court. So what's going on so far?
We set the case for appearance of counsel next week, so that Ms. Pinson. I don't see the note as to why it's set for appearance of counsel.
I think they said it because she has other cases at 18. So
The other cases.
The other cases, and so the attorney can be on.
That's right. So the public defender was appointed and the case was set to Division 18 with Ms. Pinson's other cases.
Okay.
And that was
and
what
then
we
as far
addressed.
as the protection orders and the keep the peace.
Yeah, so we issued a keep the peace order because Ms. Pinson asked for the opportunity to return to the home to gather mainly her vehicle so that she could get to work. Nothing was addressed on the protection orders because you were not present and we didn't have any indication that the protection orders were going to be addressed today. The people had not had any contact with you. So nothing has been addressed with respect to the protection orders. Ms. Pinson had asked earlier for the ability to have contact with her minor child. And I think the people were going to address with you potentially ways to procedurally to allow Ms. Pinson to have contact with her minor child by having some potential contact with you. But again, we didn't have your input on any of that. So we set those matters to be addressed on March 28th at 1:30 in Division 18. Now you're here, so I'm wondering if you have a specific position or request of the court today.
I do.
Okay, and what is that?
So I'm going to start off by saying, as far as the keep the peace order, and her getting her van, is there a possibility to do two? Because I have to go to work tonight, and then I have a babysitter here watching Lyric, and I wouldn't necessarily feel comfortable with Lauren coming inside without me being here. And then also, as far as the contact orders with my son Lyric, I wouldn't be comfortable with her having any contact without me being present. She can contact me on the Talking to Parents app. But most importantly, what I wanted to address is that her friend Austin is a big bad influence. I don't want him around my son at all. Lauren's always around him, or her, respectfully. I don't want that individual around my son or around me, and he's been trespassed from my house, and I will be I'm in the process of filing a restraining order on Austin to not be around me or my son. Austin has been unfortunately his pops passed away, but the way he's been coping is extremely unhealthy, and he's been dragging Lauren down, and I do not want that around my son at all. I don't want it around my son at all. I've expressed to him that him giving Lauren alcohol influenced Lauren to do alcohol, regardless of her medical problems, regardless of everything that we have going on due to it, but he doesn't care. He continues to supply her that, and I don't want him to also influence Lauren to do anything heavier, because that's the mother of my child at the end of the day, and I want what's best for her. And Austin hasn't been doing anything except for tearing us hands down. And also, I'm not trying to put his business out there, but it's just a simple fact that, he has what he has going on with, his identification and everything, and who he is and who he wants to be, and his relationship with Lauren, and the fact that, he has a specific type of love for her, not more or less like sisters or friends, but different. And it makes it hard for everything to happen because it affects how Lauren acts, and it affects how the entire general everything. It just affects everything. It makes everything dysfunctional because this person gets jealous, and then Lauren also wants to avoid this person getting jealous. So then that, it makes her act different towards everybody involved, me, and then even Leary sometimes. And then just a simple fact that everything is going the way that it is, and the fact that Lauren had custody of my son, and Austin knows everything that's going on, but yet Austin uses my son's empty jars of baby food as shot glasses and gives them to Lauren while, she has my son. It's not okay. And I'm tired of this, and I do not want him around my son at all. Whoever he identifies as, I don't want that person around my son. And if Lauren's going to continue to be around him, her, I don't want Lyric to be with her because it's not safe for Lyric to be in that environment. It never really is. And the way that everything went down the other day was very bad. So, and I don't even really blame Lauren, but at the end of the day, she's a grown woman, and it is what it is. But Austin, I don't know what you guys have the power to do, but he is a problem.
Okay.
And
Well,
it's
so
coming
let me
what
come
happened.
back to, let me come back to that a little bit, Mr. Womack Jordan, because the court doesn't have any authority to prohibit any additional person from having contact with you or the minor child in this case. So the only person that is restricted from having contact with you or the minor child at this time is Ms. Pinson. And so I can't, make any other restrictions on other third-party individuals. Now, in terms of the keep the peace order, I'm going to try to kind of take your concerns here to the extent that I can address them one by one. In terms of the keep the peace order, that is something that is set up through law enforcement, and I believe that they would be contacting you to set up that keep the peace. And so I believe that you would be able to set it up at a time where you can be present and be home. So that typically what it is that it gives an individual the access to the home to gather undisputed items. It's usually a very quick process for them to gather undisputed items and take those needed and necessary items. I don't believe that it would be a situation where she would be given access to the inside of the home really without you being present or setting that up with law enforcement. So there is a procedure that goes along with all of that. And I would doubt that it would be executed sometime this evening because it's usually not able to be set up quite that quickly with law enforcement. In terms of the contact that you've indicated with the minor child, it sounds like you would be okay with communication via the Talking Parents app with Ms. Pinson. Is that right?
Yes.
Okay. And then you've indicated that you're only comfortable with supervised contact as long as you are present when Ms. Pinson is with Lyric. Is that right?
Yes.
Okay.
That can I interrupt and just can you tell him that means I can't watch him when he's at work?
Okay. Well, so Ms. Pinson, just give me a moment because I want to be sure that I understand what Mr. Womack Jordan is asking for. And okay. And so I think I'll have to talk to the people about your position on how those requests could be addressed in a protection order. Mr. Womack Jordan, are you asking for any additional types of contact with Ms. Pinson or between Ms. Pinson and the minor child?
Is like as far as like where like we'll be meeting and stuff, or?
Yeah, some of the difficulty is that right now there's an order that says that Ms. Pinson must vacate your home and stay away from any other location where you and the minor child are to be found. In terms of that supervised contact, I mean, that's something for, I think, you and Ms. Pinson to work out together. And I think probably what would make the most sense to give effect to your request would be an order that you may be in the same location, perhaps in public places only. But I guess I'm just looking for whether you're asking for anything additional from the court at this time.
On the weekends from 7 a.m. to 4 p.m. is not. I would need a babysitter for those days because so like if she could like watch him, but then again like I don't know. I don't know. You know what I mean? I don't really know because I don't know. I just don't. Austin's really just a problem you guys really don't understand, and like his influence on Lauren just makes everything hard. You guys don't understand. But like I do need cause I have to work. Like I gotta work, and like I can't lose my job. I'm paying rent. I'm the only one paying rent, and the fact that my rent is so high, and I just got in a car accident, so I don't have a car to DoorDash, so I can't make extra money. So it's like real difficult, and just going to DHS and everything. And just literally this entire week has been extremely stressful. But if there is a way that, I don't know.
Your Honor, can I just say that he can't really choose, like, if he wants me to see my son or not, like, he can't pick and choose the dates and when. Like, it's like, do you want me to have contact with my son or do you not? Like, that's what I feel like is the issue here.
Well, so yeah, Ms. Pinson,
I'm just so confused and I don't understand what's
okay,
going on.
I'm just trying to get to the bottom of exactly what he's requesting, and then I'll hear from the parties on that request.
I just don't want to drink around my son. That's it. I don't want to drink around my son because when she has my son in her custody, my son spends all of his time in the car seat while she's taking shots with her friend. That's not cool. And when my son comes back to be soaking wet and starving and tripping, that's not cool. So that's what it is.
Mr. Womack Jordan, thank you. So nobody's forcing you. All I want to do is get to the bottom of what you're requesting, and then we'll hear from the parties. Okay? Nobody's forcing you to make any specific.
I wouldn't be comfortable with. It's cool if she hits me up on the Talking Parents app when she wants, but I'm not comfortable with her having lyric without me being present, because when I'm present, then that's usually when things they run smoothly, but not when she's intoxicated. And when she has one-on-one with my son, then she still does what she wants, and it's usually not in the best interest of my son. And so I don't want him to be around her without me being there. And that's that.
Okay. Thank you, Mr. Womack Jordan. Let me hear from the people. Ms. Byrne?
To be completely honest, I'm not sure how or why DHS is not involved in these cases yet. I have extreme concerns for the safety of the child victim.
Ms. Womack Jordan, Mr. Womack Jordan, just a moment. Let me hear from the people, and then if there's something else you want to add in a moment, I'll give you the opportunity to do that, but we're not going to interrupt each other.
I just gotta go to work. I just gotta go to work soon, so I'm just trying to say everything I gotta say. I literally gotta leave in like 5 minutes.
Okay. Well, I hopefully will have heard from everybody within 5 minutes, and we'll get to the bottom of it. Ms. Byrne.
So in the newest case, the child is listed on the protection order. There's also a charge of child abuse. There's also a misdemeanor 23 case in which there's a charge of child abuse. In the current case, I'm sure the court's probably read the PC affidavit, but there's concern that there's physical violence essentially around the child that results in the child getting hit in the head by the defendant, basically as she's trying to hit adult victim. There's obviously curse words being used in front of this child, and there's allegations that the child essentially had urinated on itself and was left in that condition when being brought for this exchange. This is obviously a child exchange situation that got extremely out of hand. And so there's a concern regarding child exchanges just generally based on the facts of this case. But then also looking at the 23 case, there's again allegations of physical violence around the child that results in physical violence inside the child's room. And then the defendant shoving the victim into the child's, I guess, crib or bed. in that case. And then there's also concerns essentially of alcohol and intoxication as a factor in all of these cases. I would ask the court to add provision number 8 that she's not allowed to consume or possess alcohol because it seems to be a consistent factor. There's also another open felony case where thankfully the child doesn't seem to have been around in that case, but it seems that scissors were used as a deadly weapon in an attempt to stab the victim. And so there's just a continued escalation, and now the child is back in the situation when it's happening. And so I would echo, I have concerns about her being around this child unsupervised, especially based on the fact that these aren't just child abuse charges where the kid is, somewhere in the home and there's concern for maybe their mental health or their physical safety. There's actual physical violence happening in very close proximity to the child that ultimately results in the child being hit. And so I have safety concerns for this child if we modify the protection order.
Okay. So in terms of the modification that's requested by Mr. Womack Jordan to have talking parents communication and supervised contact.
So I think talking parents communication is okay, but I would object to supervised contact because these are all happening while they're both together in the presence of the child, the one during an exchange. And so I don't know what there is to lead to believe there'd be anything different at this point. Maybe if there's some proof of a period of sobriety, there would be less concern for the safety of the child. But at this point in time, there's a large concern.
Okay, thank you.
So I'm kind of standing in for Mr. Gannon, who is stepping in for Ms. Jones, who is the attorney of record on this case. So I don't know every detail of the current situation. But what I can say is that because DHS is not involved, because we are not in front of a family court, we don't have court custody orders that say that he gets the child these days of the week and that Ms. Pinson gets him these days of the week.
An emergency custody thing.
Just a moment, Mr. Womack Jordan. Again, I'm going to hear from the attorneys. So
and I understand that that may be in the process, but my understanding is that no court orders have been put in place yet, and this court is not here to do that in replace of those processes. I would ask that first, the talking parents modification be granted, but second, as far as allowing the minor child to be seen, but only in the presence of the father, I feel like that has some potential issues that would really go more towards a family court than it would this court. I think if the court is going to modify this, and in the request that we will be making, is that Ms. Pinson be allowed to make parenting time decisions through the Talking Parents app with him to make sure that she can see her child and that it doesn't have to be supervised by him, that she be allowed to have contact with the minor child. Of course, everything has to stay lawful contact. There can't be anything otherwise. She's also informed me she is more than okay with modifying the protection order to include a prohibition on alcohol or any use of alcohol. She informs that she has been sober since being arrested on these charges and is currently in therapy. So she is trying to resolve the issues that are underlying the case. I would ask that these modifications be made so that Ms. Pinson can see her child. Again, I don't think it's fair for this court or for the alleged victim to decide that it has to be in his presence. I guess if this court is going to demand that it be in the presence of someone else, it be a neutral third party.
I disagree.
Okay, Mr. Womack Jordan, I'm going to give you 1 minute just to provide me your brief final statement. I know you've wanted to say something about a couple of things. I'm going to give you just a brief moment, but if there's anything else that you want to say, but I'm going to cut you off after about a minute.
Copy.
I'm sorry?
So, sorry. Yes, ma'am.
Okay, go ahead.
So there's never any issues in public. There's never any issues in public. Everything always happens in private. That's one. And two, I'm in the process. DHS was here after this. DHS is involved, but Lyric is well taken care of by me. And my family's helping me. And I have transportation to get him when he needs, and he's taken care of. He gets bathed, he's laughing, smiling, healthy, he's not sick anymore. So he's doing really good, he's developing. And DHS, I'm in the process of transferring the food stamps and the TANF and everything else because I am also doing emergency custody, which because I'm not on the birth certificate, because DNA test, which will get done like a paternity test to establish that I am the father biologically, which I am, and then there will be emergency custody in place, and then I'll get like DHS, like CCAP and everything like that. So he has a bed, he's warm, he's taken care of. It's just, you know, when we're around each other and we're sober, it's good, but when we're around each other and she's not, and it's not good during certain points of time. Sometimes it is, sometimes it ain't. But her being around Austin is not gonna I don't know. I just I don't want my son around him.
That's all right. Thank you. Thank you, Mr. Womack Jordan. I appreciate the additional information. All right. So the court has had the opportunity to review the contents of the probable cause affidavit in this case. The court has considered the statements and requests of the named victim and the position of the parties here this afternoon. Mr. Womack Jordan, I'm going to mute you just because I can hear the child in the background, but you'll still be able to hear the proceedings. All right, so I've reviewed the information, I've considered the arguments of counsel, I've reviewed the status of the current protection order. What I will do at this time is grant a partial modification of the protection order to allow for talking parents communication between Ms. Pinson and Mr. Womack Jordan regarding the minor child only at this time. I will also allow for the parties to have FaceTime communication at the agreement of Mr. Womack Jordan or any other video type of communication to give Ms. Pinson the opportunity to view her son basically during this period of time to allow for that type of contact with Ms. Pinson and the minor child. I think what is concerning is the fact that there's other cases that involve these individuals and other cases that involve allegations of child abuse, allegations where the minor child was allegedly struck during altercations between Ms. Pinson and Mr. Womack Jordan. So what I would do is I'll also add the condition that Ms. Pinson not possess or consume alcoholic beverages or controlled substances as a condition of the protection order. And I will defer any additional decisions regarding contact with the minor child, supervised contact or otherwise, to Division 18. It could be addressed on March 28th in Division 18 or any date thereafter. But I think at this point, given the allegations, given the number of cases that we have, given the fact that the minor child was allegedly struck during this incident, I do think that allowing just for that communication between Ms. Pinson and Mr. Womack Jordan, as well as some form of video contact, again, at the consent of Mr. Womack Jordan, at this time is the appropriate level of contact.
So can we take that as the people have been put on notice for any further modifications, or do I need to officially put them on notice for possible argument at the next court date?
Well, I think that's what you're doing here. So I will, and part of it is that Judge Gomez has those other cases, has more information about those other cases. I have not reviewed those other cases in advance of today. So I think putting the people on notice to address further modification of the protection order at the next court date, and potentially depending on how this period of the next 10 days goes, I think is something that would play into this court's consideration of the request for further modification. So that's why I do think addressing it there, and if the people are on notice, if that's your request, Ms. Boyd,
yes, please,
then we will put that note in the minute order that further modification can be addressed at that time. And again, Judge Gomez has access to more information than I've been able to review here in the course of this busy docket and this particular hearing.
Okay. And then Ms. Pinson does need to stay to sign
to sign the modified protection order. And Mr. Womack Jordan, I'm going to unmute you for a moment just to let you know that You also have the ability to receive a copy of this modified protection order that we've entered today. You can do that by coming down to the courthouse and requesting the record. You can go to the judicial website and fill out a form to request the records related to this case. You can speak with the victim advocate at the district attorney's office, or if you have access to the chat function on WebEx and you're comfortable doing so, you can enter your email address into the chat function, and we can email you a copy of this modified protection order.
Okay.
We are almost done with the protection order. Okay. All right. And we have quite a few cases remaining. Do we have any other in custodies coming? No. Okay. All right. So let's just start calling these cases. First, we have the case for Rhonda Fuller, 24 CR 1001. This case was scheduled for. Yes.
I'm sorry. I do have one question.
Okay.
Will the information for the Talking Parents app be emailed?
I believe that one of the parties needs to sign up for the app and then perhaps puts in the other party's information.
If he feels comfortable giving me his phone number, we can at least give it to the victim advocate so we can reach out to him with that info.
Okay.
Potentially.
Mr. Womack Jordan, if you'd like to give the district attorney your phone number, they can reach out to you with that information.
720.
I will pass that information along so that they can reach out to Mr. Jordan or Womack Jordan.
Okay, thank you.
Okay, so
she's the one I wish was pro se, but no, she had a lawyer. The other ones, no lawyers for them. I don't know what that guy's going to do, but clearly relying on her to watch his son or their son while he's at work is just not a good idea. And I get it. I know how hard it is. I know he feels like he doesn't have a choice. There's no one else. But I mean, if she was incarcerated, which it looks like she might be headed that way, she wouldn't be there. So he has to find something else. He has to. There's no other choice. Daycare. No one likes daycare. It's super expensive. But, he has to do something else. While those other guys we saw at the beginning just have to go to jail. They don't have to do anything. They don't have to be parents or co-parents or anything anymore because they didn't want a lawyer. So tomorrow's supposed to be the full moon, I think, right? Okay, I think. So hopefully, tomorrow we get some real good ones. But that's all I have for today. Thank you so much for coming out again, guys. I really, really appreciate it. Yeah, that woman deserves to be in jail. Absolutely. Absolutely. I get why the father is so upset. I get it. He can't blame this other girl, though. He can't. I mean, he can, but that's the mom. I mean, I choose who I hang out with based on how it will affect my children. I mean, I just do. It's the first thing I think about when I'm hanging out with someone is, what will my daughter think about this, or what would my son get? It's just automatic. It's just second nature. Oh well. Thanks, Kelly. I appreciate it. I got another Kathleen in chat. When your mom gets mad at you, did she say Kathleen? Kathleen. And I kept telling her, it's Kathleen. Thank you for coming out. It was nice to see you, Dragonfly. And Lightfoot, we love it when you come. And Just Go. And of course, Fozzie, you're the best. I hope you guys have a great day. I will talk to you as soon as I get more content. I'll look at that Utah case. I will look at the Utah case as soon as I have a minute. See you guys. Have a good day.